Now, my year one students, I'm sorry I've not been available for you. Of course, today is for you. Today we'll be looking at legal reasoning. Yeah, legal reasoning, because that's where I stopped. So, legal reasoning, what is it? Let's just get right into it. Reasoning, first of all, we have to define reasoning, we'll define legal, then we'll not join it together. You'll not see you'll not see what legal reasoning is. Very, very easy. Now, reasoning is a logical way of thinking, logical, persuasive, orderly way of thinking. So you are expected to think in a logical manner. That's when you say you are reasoning. Because when you say, okay, if this is this, then this is this, you are in a chronological manner and also in a persuasive manner. Because from reasoning, the product of reasoning is argument. Now, I'm not going into logic generally, but we will see that MI Copy has said that the product of reasoning is argument. So when you want to make an argument, of course, you have to follow some kind of chronological order of reasoning. So when you are reasoning in that aspect, when you are thinking chronologically, logically too, that is reasoning. Now, what of legal? Legal means lawful, something that is pertaining to law. Now, if you bring it together, you will now see that legal reasoning is the logical thinking or the logical presentation of arguments based on issues pertaining to law. So what do I mean? Of course, when you look at the judges, how do they reach their conclusion? Because judges reach their conclusion through a chronological and logical means. If you read judgments of the Supreme Court, you would understand what I'm saying. Because when a judge is trying to reach a particular decision, he doesn't just come and say, this person is guilty. No. First of all, you have to analyze the arguments of the prosecution side, analyze the arguments of the defense counsel, and resolve the two dissenting arguments. And in seeking to resolve them, he is talking about the particular authority that the judge is going to follow. And by that authority, applying it to this case, now when you apply it to this case, it will now lead to the conclusion. So that is the logical and the chronological way of thinking. And since it is pertaining to law, that reasoning is called legal reasoning. I don't know if you understand what I'm saying. Now we'll get into methods of legal reasoning. Now before we go into methods of legal reasoning, let us look at legal language. Now I know that most of you have been using legal language, but probably you do not understand what legal language is. Very simple. Legal language is the language that we use in law. But we are not talking about language as regards English language or French language. Of course, lawyers in France would be using French in order to converse their cases in court. But when I will talk about legal language, we're talking about how is the law usually used? How are laws usually used? In what manner of idiolect, in what manner of language is the law usually presented or painted? Now, we have understood that laws are usually written in a general sense, especially when you look at statutory authorities. When we say laws are usually presented in general sense, it means that anytime a law is trying to provide for something, it is usually providing for that thing in the general. Why? So that nobody will say that he is escaping that generality of the law. Now, the law is supposed to cover all and all, just like a blanket, so that nobody can do something, go against the law, and now say, the law did not cover my own wrongdoing. I will give an example. Law can be made in a school and say, do not break any school property. Any school property is general. It can be anything. But imagine if the law says, do not break any chair. That means if I break the school projector, I have not gone against the law. So it is important that the law is general. And the law is always trying to be presented in the generality of things, and in general. So that when you say do not break school property, even if they bring in a new property, and I go and break it, I have gone against that law. But if they say do not break the chair and do not break the table of the school, and they bring in something like a whiteboard, and I go and break the whiteboard, and they come to me and say that I have broken school whiteboard, that they will carry me to punish me, I will say no. My argument would be that the law says do not break chair or table. The law did not say do not break whiteboard. Do you understand it? So when we are talking about law, most of the time laws are presented in general sense, in the general form. However, there are some times that laws are supposed to be clarified enough in order to understand, and in those times, laws would now be presented in the specific form. Generally, it is presented in general form, but for the sake of clarity, for the sake of specificity, you try to be precise. What do I mean? For example, when you want to talk about the courts, for example, the law is trying to provide for courts of superior records. Now, if you say courts of superior records and you leave it like that, it leaves a lot to conjecture. It leaves a lot for confusion. Which ones are courts of superior records? Now, it now behoves the law to mention those specificity. It now behoves the law to mention those particular superior courts of record. So that when somebody is saying, I want to go to the superior courts of record, he will not be confused as to which ones are the superior courts of record. So when we want to achieve clarity, it is important that the law is specified, is used in specific sense. We are talking about legal language now, the language of the law. Generally, it is supposed to be in general form, so that nobody will escape the long arm of the law. Of course, when it is in general form, it will have long arms now. So it will have long arm extending to everywhere. That's why I say you cannot escape the long arm of the law. However, if it's just specific into some things, and every time you want to look at the law, there are so many rules, so many. In fact, if it is usually in specificities, or if it is usually specified, there will be so many rules and it will be confusing. So it's important to be general. But however, for the sake of clarity, for the sake of understanding, and for the sake of saying, okay, let me get what we are trying to say, it is important for the law to also be stated in precise terms. So that is legal language. So you can go and read it. Of course, another thing about legal language is that abstract terms are used. Archaic, antiquated, and grandiloquent words are used. You know, lawyers are usually known to be speaking big grammar. Yes, that's what I mean. Grandiloquent, they are doing it in a pompous way. And so most of these Latin words and all that, I don't think it is still needed, because we have reached a level where we are expected to have elevated above all those. In the UK, they have banned all these Latin words. They change everything to English language so that everybody will understand. It is important that people understand these laws so that they will, of course, obey the laws. If you don't understand something, how will you obey that thing? You understand? So in Nigeria, of course, at least because this is the one we are using, this is where we are, so we use it as a point of reference. In Nigeria, we know that when you go to a court as a layman, you that you're a law student of year one, when you go to court, I am not sure you will understand anything that they're doing in court because of the kind of language they use there. Yeah, so that is also another part. So it is usually present in abstract terms, which of course we are trying for us to evolve in order to use understandable and comprehensible words in order to pass our information in law. So let's go into method of legal reasoning. We will just explain legal logic and we'll explain legal rhetorics. Now, legal logic of course pertains to reasoning and arguments. Now, legal logic has two classifications under law or under legal reasoning. We have the deductive logic, or what we call the syllogism, and the inductive logic. Now listen attentively. In deductive logic, when we say deductive logic, we are trying to move from the generality of law. We will bring what the law provides. We will carry it, and apply it to our facts, our particular facts, and then reach a conclusion. So, what does the law provide? If you unalive somebody, they will unalive you. That is the law, generally. Obi has unalived this person. Therefore, Obi will be unalived. So in deductive argument, we move from the general to the particular being your case. So you have a case. If you want to use deductive reasoning, you would now look for what is applicable to that particular case I have. What law am I going to use? So when you find the general law, you will now apply it to your case and now reach your conclusion. That applying to your case is when you move from that general, you carry it and apply it to your particular case. And you will now reach your conclusion. I'll give you another example. Maybe your case is that they have sprayed naira. Spraying naira. They have abused naira. So you now think, okay, this is your case. This is a particular case. Let us go to the general. The general. Which law provides for it? You've seen a law, section 20 or something like that, or 24 or 22, I don't know, 21 or something, 20 something of the CBN Act has provided that anybody that sprays naira will go to jail. Yeah? Your client has sprayed naira. Therefore, what's the conclusion? Your client will go to jail. So that is deductive logic. You've deduced from the general to the particular. And when you talk about from the general to the particular, the general here is statutory authority. Write it down. Statutory authorities. Statutory authorities different from judicial authorities. We'll still come there. So when we talk about the general, we're talking about statutory authorities. Remember, in your legal language, we said that laws are usually presented or painted in the general manner. And that is the statutory authority. Statutory authority there means written laws. Statutes are written laws. Laws that are written. Judicial authorities can be judicial precedents, cases. So when we talk about deductive logic, we are mainly looking at statutory authorities, the general. Applying statutory authorities, the written law, to your case, to your facts. Then you now come to your conclusion. That is deductive logic. However, inductive logic pertains to judicial processes, judicial precedents. That is when you look at a judicial precedent, you juxtapose it with other judicial precedents and now come to a general conclusion. What do I mean? This case talks about this, this case talks about this, this case talks about this case talks about this. Therefore, this is how the law is, or this is what the law provides for, because 4 cases talks about this. Since they are in agreement, that is what the law is. Therefore, this case can apply to this matter. So I don't even know what they answer. Now, these are particulars, particular cases, particular cases. When you use the characteristics of each of the particular cases, since they are the same, you now assume that that is what the law is. That is what the law is, general. So that means for inductive reasoning, since we are looking at judicial processes, judicial precedents, we are moving from particular cases to the general. So we are coming to a conclusion that cases, particular cases with the same characteristics is what makes up the law. So while deductive is from general to particular, inductive is from particular to general. And while deductive deals mainly with statutory authorities, inductive deals with judicial precedents. Because you know that there are some judicial precedents that might not be the same. In fact, not that might not be the same. There are judicial precedents that are not the same. The court will say something different here, and say something different here, and say something different there. Now, in that particular circumstance, you are confused. But if you see like 4 different cases that is saying the same thing, okay, in Stevenson against Donovan, if you breach your duty of care, you will go in for negligence. Because the facts of the case of Stevenson against Donovan is that somebody bought something, and when she finished drinking, she now saw that there was a dead snail inside that particular thing she has finished drinking, and she fell sick. Yeah, she's now sued. So you have gotten this case. You have gotten another case that has to do with other things that still points to breach of duty of care that amounted to negligence. You have gotten like 4 cases that has the same thing. So you now come to the general principle that yes, anytime you breach your duty of care that you owe, you are negligent, and negligence is a civil wrong under tort. You have moved from specifics, particular cases, to the general principle to apply to your case. So deductive deals with statutory authority and will move from general to particular, while inductive deals with judicial precedents and will move from particular to general. Now, I want to differentiate between principles and rules before I go into legal rhetorics. Principles is the basis upon which rules are made. So the principles are the unchanging basis of the law. There's a principle of rule of law. Under the principle of rule of law, you will now start seeing fundamental rights, You now start seeing freedom of the press. You now start seeing supremacy of the constitution and all that. But the principle is the basis. We have the principle of natural justice, and under it we have rules. Principle, the basis. Under it we have rules. Principles is at the basis. Under it we have rules. So, principle of natural justice have two rules: nemo judex in cassasua and audio terem patem. So, audio terem patem, of course, you know what audio terem patem is. If you don't know what it is by now, then I don't know what you are doing in class. Audio terem patem means hear both parties, while nemo judex in cassasua means no one can be a judge in his own case. These are principles under the unchanging and under the basis of the principle of natural justice. So that when you do not follow any of the rules, you have not followed the principle entirely. So when there is a particular case that somebody has deprived the other person of fair hearing, that is a rule. Now, you have broken that rule. That means the principle of natural justice was not observed. If somebody goes against the supremacy of the constitution, you cannot say that rule of law has been violated. Somebody goes against press, media, independence of the press, you go against it. It means that rule of law has been destroyed. So the principle is the basis, and the rules are like the support, are like the children. Yeah, so get that, have that in mind. We go into legal rhetorics. Legal rhetorics is how you win your cases. You know, people that do debate, good. That is what you have been doing. You have been doing rhetorics. Legal rhetorics is how do you persuade the judge to give you judgment. Before the judge starts giving judgment, the two lawyers must have tried to persuade the judge to give judgment to them, for them to be victorious in the judgment. How do you do that? By legal rhetorics. And how do you do legal rhetorics in law? We try as much as possible to appeal to authority. Anything you are doing in law, I've said it many times, you must have to cite authorities. You are nobody in law to have to just say something without citing an authority. No. It's either you cite the judicial authority, which are cases, or you cite statutory authorities, which are sections of the law. But in order to have good rhetorics, in order to persuade the judge more, you must cite authorities. In fact, legal rhetorics is persuading the judge with authorities, either statutory or judicial authorities. So when we say judicial authorities, we are talking about cases, and cases are usually presented as Stevenson against Donogwe, Obi against Ada, this person against. So it's usually written Stevenson versus Donogwe. So when you are reading your law books, you see all these versus this. These are authorities. These are cases. When you do your stare decisis, you would now see that cases of the Supreme Court and Court of Appeal are usually used steadily because they are courts of very high records or superior records. They are superior courts. That is why they are being used, and it binds courts that are under them. So any court you are citing the authority binds the courts that are under them. So that is why in order to make the court to follow what you are saying, you must have to cite authorities that will bind them to follow that thing that you are saying. So that is legal. That's just the simple explanation of legal rhetorics. When you read it, you will understand it more. Now, I hope you've been able to learn one or two things here. I've been distracted with some noise outside because I'm not with my mic. My mic is spoiled, so I'll try to get another one. Please do well to read your books. So don't be waiting for miracle. Of course, wait for miracle, but while waiting for miracle, stay read. I'll see you in the next one. Thank you.